of the Constitution. That Constitution makes it clear which of the two things must prevail. That's the answer to your question, Justice Sondi. A section in the Bill of Rights cannot be ranked in the same status as a section in the rest of the Constitution. That's Law 101AAA. So to say that, no, you are pitting the two, that's why all these cases have been saying Section 19 is the foundation of our democracy, because it's in the Bill of Rights. So there's something called the hierarchy of laws, and it's here, but I don't have time. The court strikes this proposition. The hierarchy goes like this. It's the Constitution, obviously, legislation, and then it's delegated legislation. But in the Constitution, the hierarchy is that the Bill of Rights, that's why it's called the fundamental rights, is the, Mr. Ngobatobi talks about Section 36. You can't apply Section 36 to Section 47. Section 36 is only applied to the Bill of Rights, Section 19. So if there's anyone, I'll tell him tomorrow when I see him, who is fundamentally misguided, it is him. And so you can't, it's not like we are doing, it's not a battle of equals. Section 19 is the be all. And
the child will convey a message to him.
Yes, yes, I'll call him. I'm probably going to see him later. So that's the wrong answer. Then he's asked another question, simple question, for half an hour, I think 40 minutes. I was counting. He's asked a simple question: when did the sentence expire? When was it completed? No, it was never completed. No, it was completed when it was 3 months. And we got like every version you can think of. No, there are two answers. It was that day or this day or whatever. The answer that you are looking for those minutes, Miss, it comes from Dr. Remember, Justice Yakub has just reminded us. After all, we're here because of an appeal to what? The objection. The answer to the question that this court has been grappling with is provided by none other than our Dr. Matsapula, the real person who brought us here. He says in paragraph 6, you'll find that at 247. His objection starts at, of the pleadings, pardon. His objection starts at 246. So we have the IEC now taking up the fight, fighting a bigger fight, and going to war for this person's objection and exaggerating the objection by giving us multiple dates of completion. When the real objector gives us the answer, here it is. Mr. J.G. Zuma, paragraph 6. Mr. J.G. Zuma completed his sentence when he was released from prison on 11 August 2024, following a special remission of sentence in terms of 84(2)J of the Constitution for certain categories of certain offenders, proclamation, this and the other. That's all Mr. Mokatub should have said. It would have taken him half a second, not 40 minutes, to say the answer to that, because we are just an independent body. Here's the objector, tells us when the thing was completed. And the objector knows that there's a remission. And but we are told that all sorts of gymnastics about whether is it reduced. And well, if it's reduced, the question comes again from...
Sorry.
I'm sorry. Yes.
There might be something that we are missing here.
Yes.
But what about if that statement is a statement of law and it doesn't reflect the correct legal position?
Which statement?
Statement of action.
That statement in paragraph 6, if it's an expression, even a statement of law,
No, it's not a statement
then a
of
statement
law.
of fact.
It's a statement of law. It's a.
Because it's about his understanding about how the law applies. It's a statement that embodies legal conclusion.
No, my lord, I'm making.
I'm just putting this.
Yes, no,
so
fair
that
enough.
I can deal with it.
No, it's a valid question, my lord.
Yes.
There are two answers to it. One is that the one is the one that where I'm saying we do, as I stand here, I don't know when Mr. Nkatobi says the issue was completed. He was asked a straightforward question, and I'm saying the question is here. He could say I don't agree with Dr. Matsapul if he wanted or whatever, but I'm saying the originator, the person who brought Mr. Nkatobi to this room, is here saying that it was completed on the 11th. That's the first. The second one, the Lordship is quite correct. If indeed, if Dr. Matsapula said remission doesn't mean anything, of course the court can't be bound by that because that would be a statement of law. But in any event, maybe let's forget about Dr. Matsapula. You can hear it from me. Our version is that the sentence was obviously completed on the 11th of August 2023. There's no other answer.
Mr. Mpofu, I want you to look at, because you are referring now to Mr. Matsapola's objection and what
Dr.
he makes,
Yes.
Dr. Matsapola's
Yes.
objection and what he makes of the sentence imposed and the remission, right? The effect of the remission.
Yes.
You've taken us to paragraph 6. Shouldn't we look at it holistically? Shouldn't look at the objection holistically?
Yes.
Go to 7, paragraph 7. It says, I submit therefore that in terms of section 747(1)(e) of the Constitution, Mr. Zuma is not eligible to vote to be a member of the National Assembly in that he was convicted of an offense and sentenced to more than 12 months imprisonment without the option of a fine. A period of 5 years after the sentence has been completed. So 5 years from 11 August 2024 has not lapsed.
Yes. Yes, of course, my lady. Because we don't have time, I'm even prepared. The answer is obviously what Justice Zondo was saying. What his conclusions of law are irrelevant. But let's entertain him. Even if he is, that is what is pleading, quote unquote, then that doesn't resolve the question. The question is not that 5 years has lapsed. Because on any version, everyone knows 5 years has not lapsed. Whether it was completed after 15 months or whatever, that's not the issue. The issue is what was being addressed in the case of Freedom Front Plus Winnie Mandela. That's what the professor was raising with Mr. Nkatobi, which he did not answer. Paragraph 15 of that judgment is very clear. The gist of that judgment is this. It's the point that was being grappled with Mr. Nkatobi. You cannot, if you say in a sentence, one of his versions was that it's still not been completed. And until one of the judges made it clear, then that means he will never be exempted. Because he's continuing forever. Forever, amen. Yes. Now, and this is what the court said, TRJA in that matter. For the above reasons, the second respondent is not disqualified from standing as a candidate for the election of 22 April 2009, as she was not sentenced to an effective term of imprisonment capable of being completed within the meaning of section 47(1)(e). That's the gist of this thing.